You've probably heard stories like this before. One person standing up against a big, faceless organization. It's that classic David and Goliath setup. But what happens when that battle is in your own backyard, and the Goliath is your homeowners association? Well, let's get into it.
It seems like a simple question, right? But the answer can get really messy really fast. I mean, if the very group that's supposed to enforce the rules is the one breaking them, what is a single homeowner supposed to do?
So today, we're going to tear down a real case, piece by piece, using the actual official documents and testimony. This isn't some made-up story. This is a step-by-step look at a real fight over rules, deadlines, and who's really accountable.
So our story kicks off with one homeowner, Deborah Masear. She saw that something wasn't right. The association just wasn't playing by its own rulebook, and she decided, you know what? It's time to do something about it.
Okay, this timeline lays it all out pretty clearly. The HOA's own bylaws said they had to hold their annual meeting by March 13th. But that day came, and it went. Crickets. It's that silence, that delay, that prompts Ms. Masear to file a formal complaint almost a month later. And notice this. It's only after she files the complaint that the HOA suddenly scrambles to send out a notice for a late meeting.
And you can hear it in her own words from the official hearing. This wasn't some impulsive move. She was patient. She waited. The deadline passed. Nothing happened. And she felt like her only option was to use the formal process to make the HOA do its job.
But of course, there are always two sides to a story. So how did the HOA defend their actions? Well, their whole argument was built around something that happened almost 2 months after that original deadline had passed.
So their defense wasn't, oops, we forgot. It was more like, we were just a little late. They argued that they did try to do what they were supposed to do by setting up a meeting for May 8th. From their perspective, being late didn't mean they completely failed to do their duty.
And here's the real core of their defense. They said that when May 8th finally rolled around, the meeting was called to order, but it couldn't actually go forward. And why not? Because of a little legal term called quorum.
So what on earth is a quorum? Well, it's a super important rule for groups like HOAs. Think of it as a minimum attendance policy. It's there to stop, say, a handful of people from showing up and making huge decisions that affect the entire community. For this particular HOA, their own rules said 25% of all members had to show up, either in person or by ballot, before any real business could get done.
And this chart just puts it into stark numbers. To hit that 25% mark, they needed 35 members. But look at that second bar, only 29 participated. I mean, they were close, but in legal terms, close is the same as not happening at all. No quorum means no votes, no elections, nothing. The meeting was a complete bust.
So now you've got these two competing stories. And this brings us right to the heart of the legal fight, the central question that a judge had to figure out.
Okay, so let's boil it down. On one side, the homeowner's argument is super straightforward. The rules say the meeting has to be on the second Monday of March. It wasn't, period. End of story. But on the other side, the HOA is saying it's not our fault. They're basically pointing the finger back at the community, saying, hey, we tried, but you guys, the members, didn't even bother to show up.
And this is really the question, isn't it? Does a failed attempt, nearly 2 months late, actually count? Does that satisfy the legal requirement? Or is a missed deadline, no matter what excuse you have?
So, after hearing both sides of the story, an administrative law judge, basically a neutral referee in these kinds of disputes, made a final ruling. And what's so wild is that this entire neighborhood drama was ultimately settled by the definition of a single 4-letter word.
The judge didn't really focus on who seemed more reasonable or which excuse was better. The whole decision was based on just reading the contract that everyone agreed to live by, the bylaws themselves.
And there it is. This one sentence from the judge's ruling decided everything. The judge pointed out the bylaws don't say the meeting should be held or might be held. They say it shall be held. And that phrase, shall be held, is what the judge called not permissive. In legal speak, that's a total knockout punch.
That word, shall, isn't a suggestion, it's a command. It creates a mandatory duty that you can't just ignore. So the HOA's whole argument that they tried to hold a meeting later and that it was the members' fault it failed? Completely irrelevant. They had a legal obligation to hold that meeting on March 13th, and they just didn't.
And the result? A clear, tangible win for the homeowner. The judge sided with her completely, found the HOA had violated its own rules, and ordered them to pay Ms. Masear back the $500 she had to spend just to file the complaint.
So you might be thinking, Okay, a homeowner wins $500, big deal, why are we talking about this? Well, because this tiny little case actually reveals some huge truths about how our communities are run, and more importantly, how any one of us can hold them accountable.
So what are the big takeaways here? First, your HOA's bylaws, they're not just a friendly guide. They are a legally binding contract. Second, words matter. A lot. Shall means must. No wiggle room. Third, an organization can't just blame its own members when it fails to do its job. And maybe the most important lesson of all, this proves the system can actually work. One person who takes the time to understand the rules can absolutely use them to make a powerful group play fair.
And that really just leaves us with one final thought. This whole thing was won because one person actually read the rules and took them seriously. It kind of makes you wonder, doesn't it? How many of us can say we've done the same?